Warning: the content of these videos contains adult themes which may be distressing. Viewer discretion is advised. Everything you are about to hear is taken from court documents, trial transcripts and various media sources. Hello everyone, and welcome back to True Crime with Mystery Maverick. Today we continue to look at the aftermath of Darlie's arrest and the family's fight against the powerful systems. We dive further into the case files and the pre-trial hearings that ensued as we delve into the mystery, dying for justice, the wrongful conviction of Darlie Routier. Back in the Dallas County Courthouse, in the hearing to hold Darlie without bond, the cross-examination of lead investigator Jimmy Patterson would continue. Huff played the 911 tape in open court and told Patterson to listen carefully for the impending questions. Huff went on to ask him if he could hear the glass breaking during the recording, to which he replied, "No, sir." When asked if they had collected the stem of the glass, he said that he did not know. Huff used this opportunity to point out other evidence that wasn't collected, including the baseball cap in the utility room, even though Darlie had told them that the suspect was wearing a black ball cap. He further brought up the fact that the district attorney's office had to run an evidentiary search warrant and go back for the cap at a later date. Under redirect, Davis asked if Patterson had seen the cuts on Darlie's hands when he went to visit her at the hospital, to which he replied, "Yes, sir." This point goes further to show that Darlie had defensive wounds immediately after the crime and did not inflict these on herself in the days after leaving the hospital, as some have suggested. He then asked the detective if he had seen any visible blood on the countertop above the sink. Patterson stated there was no visible blood on the countertop at the sink. He did say there was a few drops inside the sink. Davis asked about the luminol testing, and Patterson said it had looked as if someone had wiped blood off the ledge of the sink. This statement is not supported by the crime scene photos of the sink, where you see copious amounts of blood on the ledge of the sink and watered down blood drops on the front of the cabinet doors. The luminol testing is something that was later omitted at trial, and no one testified to carrying it out. No photos were shown, and a cleanup was never mentioned at trial. I believe this would have been powerful evidence for the state, and therefore would have been used against her had the results had any significance in proving her guilt. Davis then asked the detective if he had ever seen Darlie cry like she had on the tape. "I saw her act, I never saw any tears," replied Patterson. He then asked the detective if besides the broken glass any other items in the home were broken, to which the detective replied, "No, sir." Under recross, Huff asked if he had fingernail scrapings taken from Darlie, to which Patterson responded she didn't have any. "Did you even try?" countered Huff, to which he replied, "No, we did not." He went on to ask Patterson about the cuts on Darlie's hands and if she had told him how they had gotten there. He said that she didn't know herself, but thought they might have been from the knife. Huff asked him as a detective if he had any professional opinion on the cuts, to which he replied, "No, sir." Again, I find it strange that someone who is supposed to be a lead homicide detective has no clue about defensive wounds or crime scene pattern recognition and analysis, yet seemed to know information of a trauma surgeon, such as Darlie's wounds were not life-threatening. Furthermore, it seems like he had little involvement in the crime scene and coordination or organisation of his team. Huff directed the detective back to the sink and the fact there was noticeable blood down the front of the sink, and why someone would clean the ledge and not the front of the sink if they were trying to hide evidence. He further pointed out that if someone was running water in the sink, that the blood would have washed down the sink area and may appear to be washed away or diluted. The detective conceded that this would be the case. Finally, Huff asked Patterson if he himself had an opinion on the crime. Patterson stated that he believed that the crime was planned but not very well. The final witness called by the state was trace evidence analyst Charles Lynch. Davis began by asking Lynch about the utility room floor and if he had seen any evidence of the knife being dropped in that area. This was somewhat of an arbitrary question in that Lynch had no specific training in blood spatter analysis, and also that Darlie had never claimed whether the knife had been dropped or not, just that she had found it in the utility room. Nevertheless, Lynch stated there was no indication that a knife had been dropped, as he would expect to see cast off. However, there is some evidence of some type of cast off running down the washing machine that he does not mention or state how he thinks that may have gotten there. Davis then asked about the footprints near the kitchen sink. Lynch stated that there was a considerable amount of blood on the rug beneath the kitchen sink and only bloody footprints leading away from the sink into the living room. This is inconsistent with Patterson's earlier testimony that there were bloody footprints underneath the drawer where the towels were kept. This further goes to prove that Darlie had wet towels at the sink and returned to the living room to put a towel on Damon's back. He went on to say that the sink appeared to be washed down except for blood that was watered down inside the sink. Again, there was plenty of blood on the ledge and down the sink, which is consistent with Darlie wetting towels at the sink with the tap running. Davis pointed out the footprints underneath the vacuum cleaner in the kitchen. Lynch said that although the vacuum cleaner had already been removed by the time he had arrived at the scene, that the footprints were in the area where the vacuum would have been. He then turned his attention towards the wine rack and asked Lynch if he had seen any signs of a struggle by the wine rack. Again, this was an arbitrary question, as there was no documented statement from Darlie claiming to have struggled with the suspect near the wine rack, and again this was not the expertise of Lynch. Nevertheless, Lynch answered with full confidence that there was no cast-off in that area, and the only blood he had seen was high up on the plate of the light switch, consistent with a bloody hand turning on the light. Davis then asked Lynch about the blood in the family room and how it appeared, to which he stated the obvious, that it was consistent with 2 children being stabbed. He then stated there was no blood on the couch, a statement that is not only inconsistent with Patterson's prior testimony, but also contradictory to the crime scene photos. He went on to say that the fact there was no blood on the couch Darlie had claimed to have slept on was inconsistent with the amount of blood on Darlie's t-shirt. This statement fails to recognise the significant amount of blood on Darlie's pillow and on the edge of the couch, but further ignores the basic scientific principles of gravity, that most of the blood on her t-shirt would have been deposited after she had stood up. He further stated there was no bloody footprints leading from the couch towards the kitchen. This point further goes to support the fact that Darlie went to the kitchen sink to wet towels after she had been bleeding for some time. I will address this in further detail on episode 4, where I will analyse the crime scene evidence presented at trial. He stated that he only saw blood transfer on the couch that was consistent with a child passing by the couch when injured, and said that this was further substantiated by the bloody handprint of a child on the carpet. This further supports the claim that Darlie made that Damon had followed behind her. Davis asked Lynch if he had formed an opinion about the crime scene and what the evidence suggested. His opinion was that the crime scene was staged because there was blood at the sink and that the children's wounds were precise and the blood drops in the kitchen and utility room were in slow motion. Again, Lynch was not a blood spatter expert and did not analyse any of the blood patterns at the crime scene. He went on to say that the cut screen was curious because in his opinion, intruders don't cut screens, they pull them off. This statement is strange in that it may have only reflected what he had experienced himself and discounts the hundreds and thousands of other home invasions in which screens are cut to gain entry. A phenomenon which is known as the black swan theory. If you only ever see white swans, you ignore or discount the possibility of seeing a black swan and are not receptive to an unexpected occurrence. Davis asked him about his involvement in the analysis of the window screen. He stated that the screen had initially been sent to the Dallas Sheriff's Office for laser printing and then returned to him at Swift's. He said that it was his opinion that it could have been cut from the inside or from the outside. The screen would later be proven at trial to have been cut from the outside. He said that he had been asked to look for scratches on the glass and that although he said there were scratches present, they could not have been made by a kitchen knife, and something else that he could not identify would have been used. He said that he had found a single hair in the track of the screen and that he had done a microscopic comparison with Darlie's hair. He concluded that the hair had the same characteristics as Darlie's hair in that it was partially bleached with some regrowth. The hair was later identified through DNA analysis to be from a female officer at the crime scene, which further goes to show the limitations in the precision of microscopic analysis in identifying trace evidence, and something we will go into later in the series. Davis then asked him about his examination of the butcher block found in the Routier home. Lynch stated that he had examined the knives inside the butcher block and had found a single microscopic fibre on a serrated bread knife from the block. He said that he compared the fibres from the window screen. He concluded that the fibre was consistent with the screen fibre and the knife could have been used to cut the screen. Again, this method of comparison is questionable and would be something that he himself would later question after trial. Under cross-examination, lead attorney Douglas Parks asked Lynch about blood spatter and what books he had used for his knowledge. Lynch named some authors of the publications on the subject, including Herbert MacDonald and Bob Spaulding, further showing he had no expertise in blood spatter analysis. Parks then questioned him on the DNA testing and if they had determined whose blood was where at the scene. He stated that the DNA testing was an ongoing process and that he hadn't been given any of the results yet. Lynch went on to testify that he did not see the ball cap on the middle of the utility room floor and that he believed that it was between the washer and the dryer and that someone may have moved it. Parks asked him about the blood in the garage and if any of it appeared to be a shoe print. Lynch said the blood was smeared and that he couldn't tell if it was from a shoe or a foot. He further stated that the blood had been collected and that there was no other blood in the garage, a statement which is inconsistent with later testimony of serologist Catherine Long. Parks brought up the knife again and suggested that signs it had been left in the utility room were dependent on various contingencies such as the amount of blood on the knife and if it had been dropped or placed on the floor, to which Lynch agreed. Parks went through the notes submitted by Lynch and directed the analyst towards samples he took from the scene. Of salience was a bloody boot print found behind the sofa Darlie had slept on. Lynch stated that he had told the police to take a cutting from the carpet, but said in his opinion the print was indiscernible, and in his opinion it could not be used to include or exclude a known print. A point that was in direct contradiction to James Cron's later testimony that it was consistent with that of one of the paramedics. Parks asked him about the screen and if an intruder went out of it, which way the fibres would lay. Lynch stated that the screen could lay either way as the fibres were very, quote, elastic. Parks asked if someone with blood on their clothes could have gone through the screen without leaving blood on it. Lynch stated that may have been possible. He further stated that the suspect may have only had blood on their hands, but beyond that he said it would be speculation. This is often a common misconception in violent crime that the perpetrator would be dripping in blood. Most of the blood at the scene had been deposited after the crime had occurred when Darlie had gotten up. It is likely the perpetrator had very little blood apart from on his hands, and any cast-off may have absorbed into the material of his clothing. Parks turned his attention to the fence in the backyard and asked if someone had gone over the fence if they would have left any traces of blood. Lynch said that any blood on the fence may have been missed or may be so slight that it was not found. Parks asked him about luminol and if it was reactive to other substances other than blood. Lynch stated that there were several substances that react to luminol, one of which was copper, but he could not recall the other substances offhand. Finally, Parks asked him what his opinion was based on the appearance of the crime scene. He stated that the scene was consistent with Devon being attacked first and then Damon either being attacked in the living room, then either collapsing on his own where he was found, or being attacked again. There is no proof or evidence to substantiate this idea, and this is pure speculative in nature. He said that the kitchen sink was consistent with an adult standing either self-wounding or after being wounded and blood shedding down the sink and onto the floor and cleaning the stainless steel part of the sink. He said that the blood leading to the utility room was consistent with a wounded person walking from the sink to the utility room. This fails to recognize the various blood drops in the area from the sink going back into the living room. Furthermore, he could not conclusively say whether Darlie was self-wounded or wounded, and again this was complete speculation. He went on to say that the screen was consistent with being cut from the outside. He said that the cut was smooth and had been applied in one uninterrupted stroke. He further stated that it was consistent with being cut using a serrated blade, a point that would become highly significant later at trial. Davis called Darlie Routier to the stand again and he played the interview at the gravesite and asked Darren to verify the interview he and Darlie had participated in. Parks would then ask to call some witnesses of his own, including the second investigator in command, Chris Frosch. He stated that he may offer some contradictory testimony to that of Detective Jimmy Patterson. Davis objected to this and stated that he did not believe the defence were entitled to full discovery at this time and that the burden of proof was solely on the state in the hearing and that he believed the state had met their burden of proof. He further stated that the defence were only able to offer exculpatory evidence to which the state had already presented and that they had not spoken with any of the witnesses and therefore did not know if what they would say would be contradictory to testimony already heard. Parks further tried to call James Cron, David Neighbours and Sergeant Matt Warlin on the same basis that he believed that they may provide evidence contradicting the state's other witnesses. Davis would object each time, reiterating the same argument that the burden of proof was on the state. Ultimately, the judge denied the request for any of the witnesses to be called, and no witnesses for the defense testified at the hearing. The hearing concluded with arguments from both sides regarding the motion to hold Darlie without bond. Davis stated that the state had met their burden of proof in the case, and not only would a jury find the defendant guilty as charged in the 2 indictments, but they had answered the special issues in such a way that the court would be required by law to impose a sentence of death on the defendant, and with that he asked the court to hold her without bond pending trial. Parks would counter this argument by reminding the court that under a person's constitutional rights that they were presumed innocent until proven guilty. He argued that until this was ruled on by a jury, that this was essentially an attack on the presumption. He stated that the bond imposed was already 20 times higher than any bond previously approved by the Court of Criminal Appeals, and claimed that the state had brought about this motion in the fear that the appeals court may reduce it. He argued that the evidence brought by the state was far from conclusive, and that it was full of speculation and incomplete, with no testing done to prove anything. He said that the state's case was asking the court to overlook the defendant's constitutional rights based on coulds and maybes. He referenced the medical examiner's testimony and that she could not answer a direct question such as if Darlie's wounds were self-inflicted or not. He said that this evidence was pertinent in that if the wounds on Darlie were not self-inflicted, then someone else had to have inflicted them. He said that if this had been a trial before the court, that it would have been their duty to return a verdict of not guilty. With that, he asked the court to respectfully deny the motion put before them to hold the defendant without bond. In an emotionally charged counter-argument, Davis said that the state had shown that Darlie had savagely killed her 2 children and had butchered these 2 children with deep and repeated stab wounds. He said that the state had shown that Darlie's differing stories given to authorities were inconsistent with the physical evidence found at the crime scene. He said that Darlie Routier had testified that he had not killed the children and there was only one other adult in the house. Lastly, he said the gravesite videotape was a disgusting scene and Darlie had shown no remorse. The judge said he was going to retire to consider the evidence presented to him and adjourned the hearing to the following day when he would inform them of his decision. The medical examiner testified about injuries she had not examined and could not even say with any scientific probability if Darlie's injuries were self-inflicted. The lead detective and the first responder could not remember details about the case, most likely due to their lack of professionalism in taking notes and appropriately documenting what happened the night of the crime. Both Patterson and trace evidence analyst Charles Lynch testified about evidence they were not qualified to testify to, and more generally, much of the testimony was highly speculative and seemed to be based on feelings instead of verifiable facts. Nevertheless, the following day, on the 28th of August 1996, the judge returned his decision. Ultimately, he ruled in favour of the state and Darlie would be held without bond pending a criminal trial. On the 11th of September 1996, it was the police department's turn to violate the gag order when Assistant Chief Deputy Bob Knowles of the Dallas County Sheriff's Office disclosed to the Dallas Morning News, "Darlie seems to be getting along fine in jail. She has shown little grief about her situation." A statement that would later see him hauled into the court before Judge Toll along with Darlie Key and Darren. Meanwhile, Parks, on the 12th of September at the first pre-trial hearing, filed a motion to Judge Toll requesting a change of venue, as he had been under the impression that Darlie could not receive a fair trial surrounding the publicity of the case in Dallas. The judge granted his motion and advised that the trial be held in any district outside of Dallas with no objections. This was arguably one of the most detrimental decisions made in the case, as Darlie would be tried in the southern region of the United States known as the Bible Belt. The small ultra-conservative town on the outskirts of Texas was by no means open-minded and would be an uphill battle for a case involving the murder of children. With no chance of posting bond for Darlie and having raised the funds, Darren and the family would need to make a decision about how best to use them. They had become somewhat disillusioned with the public defenders, as they seemed to be losing at every turn. Perhaps even more concerning to Darlie Key was the camaraderie she had seen between the defense team and the presiding Judge Toll, and how they seemed to be more concerned about sharing their tales of hunting together, a pastime that was directly connected and part of the culture in Kerr County. I swear I felt like I was in the Twilight Zone, with the judge and the defense and the prosecutors joking and talking about hunting. And I was there fighting for Darlie's life and for the truth about what happened to my murdered grandsons, she told Kathy Cruz. In an interview in the book Dateline Purgatory, Kenneth Waits said, "I told Darren, you keep losing, you're losing every battle." He said that at the time he had urged them to hire a competent attorney and had even provided them with a contact for a well-known Dallas attorney named Peter Lesser. Although they had initially met with Lesser, the family felt they couldn't afford him, and Kenneth felt that their goal was getting Darlie out on bond. Kenneth further recalls Lesser telling him, "She's not getting out on bond, they need to get an attorney." Although Darren and the family had Darlie's best interests at heart, they were somewhat naive to the workings of the system. After all, they knew nothing about courts, lawyers, juries, and even less about capital murder trials. On the 21st of September, Key, Darren, Knowles, and their respective representatives would face Judge Toll in a hearing regarding the violation of the gag order. Darlie Key and Darren would be represented by one of the top Dallas defense attorneys, Douglas Mulder, in the hearing, and Mr. John Weddell would represent Chief Knowles. The judge would first address Key and stated that as she had not yet been subpoenaed at the time of the radio interview, that she was not subject to the order and therefore was not in violation of it. Next, he would address Darren, who had been subpoenaed and therefore had violated it. However, because Darren had not spoken about any of the details pertaining to the case, the judge let him off with a firm warning. Finally, he addressed Knowles and the fact that he was unaware of the gag order. He ordered that Knowles informs the entire sheriff's office that they are now under subpoena and they were to make no further statements regarding the case. Essentially, all parties were given a slap on the wrist and no further action would be taken in regards to the gag order. On October the 21st, on the day of jury selection, Doug Mulder would announce to the court that he had been retained by the family to defend Darlie in the capital murder trial. He had somewhat of a reputation in Dallas as an effective attorney, who through his tenacious hard work and charismatic personality had been given the nickname Mad Dog Mulder. Outside the courtroom, Mulder would address the news reporters saying, "It's an interesting case and I look forward to trying it." During the hearing, Mulder would request an order to have Darlie's hair dyed. Her bright blonde, perfectly preened hair had since become completely eclipsed by her dark brown regrowth, and Mulder wanted to present a wholesome image to the prospective jurors. The judge called in the potential jury members and introduced them to Darlie, the attorneys, and the court clerks and bailiffs present. He commenced the proceedings by reading the grand jury indictments along with the penalty range as life imprisonment to death by lethal injection. He reminded the jurors of Darlie's constitutional rights and that the burden of proof was on the state of Texas to prove her guilt beyond a reasonable doubt, based on the evidence they present. He further gave them instructions on their legal duties if they were to be selected as jurors in the impending criminal trial. The first part of the hearing was a chance to whittle down the number of jurors through a process of exclusion and disqualification. Ultimately, the judge advised that only a limited number of reasons for exclusion, including special circumstances such as childcare issues and specific medical conditions or surgeries. Those with felonies, outstanding court cases, or pending charges would be disqualified from the proceedings. The judge affirmed that he would not excuse anyone for work purposes under any circumstances. By the end of the hearing, several jurors were dismissed based on the reasons mentioned and one on the basis of a terminal illness. The jurors were then given questionnaires to fill out and would return a week later for individual voir dire hearings between the 28th of October to the 18th of November 1996, where they would be questioned about their answers and their thoughts and beliefs on the death penalty. At the end of the hearing, the court would hear the motion brought by Mulder to return the venue to Dallas County, which the judge denied. Mulder asked the judge to reconsider the motion once the hearing had concluded, but his pleas would fall on deaf ears. Much controversy has surrounded the decision to hold the trial in Kerr County. While some believe it was to facilitate Judge Toll's extracurricular activities like hunting, others believe that it was a calculated move due to Toll's impending retirement. In the book Dateline Purgatory, Lloyd Harrell stated, "The change in venue was necessary for Toll to be the trial judge for the case because his retirement was to become effective on January the 1st, just a few days before the trial was to start. If the venue had remained in Dallas County, the newly elected Judge Bobby Francis would have presided." He further went on to say that the change of venue benefited everyone except the person it was supposed to benefit, the defendant. In an episode of Death Row Stories, second chair on Darlie's defense said, "Doug Mulder always says to me, he says, 'Mosty, if I ever get murdered, I want you to promise that my murderer will be tried in Kerr County.'" Darren and the family felt confident that if anyone could help Darlie, it was Mulder and his experienced team of attorneys and investigators. Outside the courtroom, Darren proudly stated, "I'm very happy, he's the best." On the next episode, I take you inside the courtroom of Darlie's capital murder trial, where I will examine and analyse the evidence in detail against Darlie, and I will take you inside the crime scene as we continue to unravel the mystery, dying for justice, the wrongful conviction of Darlie Routier.